Remulla with a very simple question. Is the Constitution the supreme law over all other laws? Simple lang po.
Yes, ma'am.
So it is also supreme over all other treaties.
Yes, ma'am.
Kapag nagkaroon ng conflict sa Constitution at yung Rome Statute, alin ang maghahari?
The Constitution prevails.
Kapag may pag-iiba sa saligang batas at yung RA 9851, alin ang mangingibabaw?
Ang saligang batas po.
Parati ang saligang batas, di po ba? Maliwanag
Yes,
ho yun. The President has been saying that the country was just complying with obligations and commitments to the Interpol in arresting and turning over the former President to the ICC. For the nth time, liwanagan na lang natin, a red notice from the Interpol is not a warrant of arrest. Is that correct? Perhaps the PCTC can help us here.
Tama po kayo, Madam Chair. Ang red notice po ay hindi siya ang warrant of arrest.
At ang pagka-alam ko, nung November 21, 2024, may nakita ako pero hindi ko na mahanap ngayon, biglang nawala sa ating website, sa DOJ website, isang legal opinion tungkol sa UAE na sinasaad na hindi maaring ang Pilipino ay hindi hayaan umuwi, ano? Maliwanag po 'yun. Kaya't nagtataka ako kung baka naman si Attorney Chan may kopya pa nun kasi ikaw raw yata yung author. November 21, ito tungkol sa UAE to. Walang kinalaman dito sa PRRD.
Good afternoon, Madam Chair. I do not recall having issued a specific opinion on that date, Your Honor.
Would you recall number 50? A memo number 50. It's no longer in the website for some mysterious
opinion
reason.
number 50?
If you could just look it up, we'd be very grateful.
We'll
and
get
we'd
back
like
to you
have
on
a
that
copy.
within the afternoon, Madam
Sige,
Chair.
Attorney Chan, maraming salamat. Ngayon, yung tinatanong ng lahat, yung obligasyon sa ilalim ng isang treaty, ibig sabihin ba, ligtas na sa ating Bill of Rights sa mga karapatan pantao? Ibig ko sabihin, kapag may obligasyon ng Pilipinas sa ICC, sa Interpol, do we still have to comply with the Bill of Rights that guarantees the rights to the accused and to the arrested?
That's a given.
Certainly, the Bill of Rights is there precisely to limit the powers of the government, and if the government can circumvent the Bill of Rights by just entering a treaty, then the rights guaranteed under Article 3 of the Constitution are no longer secure, hindi po ba? So, can compliance with the ICC obligations allow the government to disregard the Bill of Rights? Hindi po ba? Maliwanag po yun. At for the same reason na talaga ang nangingibabaw sa lahat ay yung ating konstitusyon. So kahit papano napilitan na maaresto at itangay ang dating Pangulo sa ICC dahil daw sa ilang obligasyon, pandaigdigan, kinakailangan talagang sumunod pa rin tayo sa ating saligang batas, lalo na yung Article 3. Talagang sagrado po yun, di po ba? Yes.
Yes, ma'am.
So, ang tanong namin at tanong ng lahat ng sambayanan, bakit ang pamahalaan, ang administrasyon, hindi muna kumuha ng court-issued warrant galing sa Pilipinas bago inaresto si Presidente Duterte? Why didn't the administration secure a court order before flying the President out of the country? Nung last hearing, may sinasabi si Secretary Remulla na yung nangyari surrender, hindi extradition. At hindi katulad ng extradition, sa surrender, hindi kinakailangan mag-issue ng warrant of arrest para damputin ang dating Pangulo. Tama po ba yun? Kasi yun ang sinabi nyo dati nung
Mga extradition kasi, hindi ho natin pwedeng gamitin dito sapagkat hindi tayo pwede mag-file ng extradition dahil nasa atin po yung tao. Ang extradition po na sinasabi ng batas ay yung court o yung arresting state, yung state pala na may warrant, ang mag-file ng extradition sa Pilipinas. Kaya surrender lang po talaga ang option natin. Wala ho tayong ibang option.
Kabisado ko po yan. Panahon pa ng tatay ko, yung extradition law natin. Ako yata nag-type nung bata. Ang tanong dito, under surrender, there's no need for a Philippine court to issue a warrant. Ang sabi po ninyo. That's the stand of the government. Is that
Opo,
correct?
iyan po yung aming stand.
Does this not contravene the Bill of Rights that we've already agreed upon as being sacred and above all else, particularly the right of deprivation of liberty without due process,
Yung due process
and
po
the right
kasi,
of liberty of abode?
kasi ang due process po dito, yung sa issuing body, yung nag-issue po na warrant of arrest if they observe due process. Ang alam po natin, 7 taon pong inimbestigahan itong kasong to, nagbigay po ng notice to sa mga kinauukulan na maaari nilang kasuhan. At pinayagan sila sumagot. Alam ko po yan na binigyan sila ng notice, may mga tanong na binigay sa kanila, pinayagan po sila sumagot. Kung ayaw po nila sumagot,
7
it's
taon
our own
ito
look.
sa ibang bansa, hindi 7 taon dito sa Pilipinas.
Opo, habang tayo po isaklaw ng ICC,
Hindi pa rin saklaw yan sa ating batas.
Hindi,
Kasi
ano ho?
ayon sa ating batas,
Hindi,
maliwanag
habang
na.
tayo po ay saklaw ng ICC, binigyan na po ng due process yung mga tao.
Madam Chair.
Yes,
can I interject?
Senator De La Rosa, please.
May I know from the good secretary, saan kayo nakakuha ng information na yan? Na yung mga
Ganun ho kasi
souvenirs
ang-
binigyan ng tanong, pinapasagot yung mga akusado. Saan po kayo nakakuha ng informasyon na yan?
Tsaka sinusubukan po nilang kausapin. Yun po yung alam ko. Talagang
I'm asking about yung sinabi mo kanina.
natural po yan,
binigyan.
nakalakaran, kasi kahit anong korte po, ay binibigyan ng pagkakataon na sumagot ang tao sa mga paratang sa kanya.
I was not.
Senator Bato, nakalista ka. Binigyan ka ba ng pagkakataon noong nakaraang 7 taon na sumagot sa anumang aligasyon?
Meron nag-communicate sa opisina ko na gusto akong kausapin. So that's it. Hanggang doon lang.
Siguro hindi
Kinausap niyo ba ho?
sapat na due process.
Kasi kung kinausap niyo, marahil ay sinabi na sa inyo yung nais nila sabihin.
Bakit ko kausapin? Sinabi mo na nga na hindi niyo recognize yung jurisdiction ng ICC. Kayo mismo, from DOJ. Ilang bisis mo sinasabi noon, Madam Chair, na hindi na recognize. Ako pa, i-recognize ko na ako mismo ang kinakasuhan?
Meron
kayo na
ho
nga,
kasing-
gobyerno na kayo. Kayo na nagsasabi na hindi nyo na-recognize. Bakit ako pa mag-recognize?
Meron po kasing residual powers ang ICC eh. Yung po
Sabi
yung
ninyo, 1 taon lang yung residual power.
Oho,
So,
pero
bakit
yung
2019 to 2020,
yung buong ano ho,
bilang
yung
yun?
buong panahon na dumaan mula 2011 hanggang 2018, ito po ay panahon na meron pong jurisdiction ng ICC sa ating bansa, sa ating mga citizen. Ngunit katapos nun, nawala na ho yung itong, hindi na ho na natin maaring kilalanin sapagkat umatras po tayo sa pamagitan sa ICC nung inatras po ni President Duterte noong 2017 na naging effective lamang noong 2018.
Madam Chair, if I may.
Yes, Senator Bato.
Siguro, Secretary Remulla, you are aware about yung dalawang dissenting opinion na sinabi ng dalawang miyembro ng pre-trial chamber ng ICC na nagsasabi na yung jurisdiction, about temporal jurisdiction, ang magti-trigger lamang ng investigation is yung paghihingi ng pag-request ng permission ng prosecutor to the ICC. At ito'y ginawa nila 2 years after nag-effect yung ating withdrawal from the ICC. Ginawa po nila yan 2 years. Kaya nga dalawang dissenting opinion yun eh. So sana, kung tayo, if you want to interpret itong mga bagay-bagay na ito, sana we have to interpret it in favor of our people. Tao natin ito eh. Pilipino ito. Bakit natin papaboran yung mga foreigner na mga banyaga na yan? Sila na nga nagsabi. It was the request for to conduct investigation was triggered 2 years after nag-effect yung ating withdrawal. But then again, Madam Chair, I will leave it at that. Please continue.
Yes, Senator Cayetano, please.
Just a manifestation on that point, and of course, our friend, the DOJ Secretary, can rebut or give a retort. Magandang hapon po sa inyong lahat. Justice Azcuna, thank you very much po for giving us time and being here today. Actually, isang main contention siguro yung residual power sa case sa Supreme Court, and as the Justice Secretary said, it's sub judice, and of course, everyone will be waiting for the decision of the Supreme Court. Ang point ko lang kasi, both sides, the pro-Duterte, anti-Duterte, want accountability. The pro-Duterte feels that the accountability is the drug lords, etc. And if President Duterte did something that amounts to a crime, pero ang accountability dapat dito sa Pilipinas at tamang proseso. So doon naman sa gustong i-hold, anti-Duterte, gusto siyang i-hold accountable, siguro naman it's safe to assume that they also want yung tamang proseso. So the thing is, there was an actual Supreme Court case, the Pangilinan versus Cayetano, questioning, I think the Secretary of Foreign Affairs noon, kaya named, questioning nga yung kung kailangan ng Senate concurrence yung withdrawal ng natin from the Rome Statute, no, from yung ICC. Pero nakalagay din dun sa case na yon, let me paraphrase, that the Supreme Court can continue to review yung actions nung executive. So my problem with yung interpretation dun sa residual powers, kasi nga, di ba, sa 5 judge sa ICC, yung 2 nagsabing, wala kaming jurisdiction. Kasi nung sinimulan namin yan, tapos na dun sa residual na 1 year. But 3 justices said na pwede. So my problem kasi is walang World Supreme Court eh. So there's only the ICC Court, then the Appellate Court. Unlike kung dito natin final sa judiciary natin, then yung interpretation, whether they still have jurisdiction or not, would have been done under Philippine law. And President Duterte would have been able to present his case not only as to jurisdiction, but as to whether or not there is probable cause. So I'll stop there, Madam Chair. And again, I think this is a point of disagreement, but I just like to manifest that, no, that we can argue back and forth whether or not may jurisdiction ng ICC, and the reality is nandun na si President Duterte. But for future cases, whether it's Senator Bato or others named, I gave 2 examples, no? If suddenly there's a witness from Marawi and they said that our troops killed children and women, and then nag-issue ng arrest ang ICC, or if the military suddenly uncovers a mass grave in any part of the country and says na nilibing yan during 2011 to 2015, I want to know whether the ICC can issue a warrant and then pwedeng idiretso na silang i-expel, i-deport, or whatever we call it. And I guess in the finality, Secretary, is that the Supreme Court will rule on that. No? But just to clarify matters, I want to put that on record, that that's what I want clarified. Madam Chair, thank you.
Maraming salamat kay Senator Cayetano. Gusto ko lang ipaalala, and I think Executive Director Alcantara is here. In the diffusion notice, if we will recall, on the 2nd page, apakaliwanag na nakalagay with a view to extradition. Walang binabanggit na surrender. With a view to extradition and assurances given that extradition will be sought. 2 beses inulit ng Interpol to. Extradition is explicit. Secretary Remulla, kung obligasyon natin, ang obligasyon natin, extradition. Pati yung Interpol, yan ang sabi.
Sila ho ang magka-file ng extradition, hindi po tayo. Hindi ho namin option yon. Yung po option po nila yon. Hindi namin option yon. Kasi ang option lang po namin, surrender lang. At sasagutin natin ang extradition kung sila po ay mag-file. Under the law po.
Liwanagin natin, ang surrender option kapag foreign national. Ang liwaliwanag po niyan nandito sa ating batas, at hindi rin kayo nag-intay ng request for extradition, even though only 12 to 15 hours as measured by
Wala pong
General
particular
Parra.
reference yung 9851 sa foreigner. Ito po ay sa offender lang ho, sa accused. Yun lang po ang reference ng 9851.
Makikita natin, kasi kinalkal na natin dito sa Senado, nanggaling rin sa Senado yan, na ang nakasaad sa Article 17, yung dulo, RA 9851, talagang maliwanag na surrender para sa foreign national. Ilang beses na rin pinaliwanag ni Attorney Medina yan sa first and second hearing na maliwanag na para sa foreign national yan. Kaya mukhang malabo ito.
Sa interpretation po yun, hindi ho sa batas yun.
Nasa transcript po, ang liwaliwanag, may amendment si Senator Subiri at the time, nakalista lahat ng bills pending, pare-pareho po ang referral sa foreign lang, hindi po pwede sa Pilipino. Hindi bale, tulad nga ng sinabi ni Senator Cayetano, we agree to disagree, hindi po pwede para sa amin, maliwanag. And I'd like to call on Justice Azcuna at this juncture. Reference has been made to RA 9851, yung Article 17 nga na sinasabi, na sa ngayon, hindi na yung Rome Statute kasi post-2019 na tayo, no? So, ang huling kataga, pursuant to the applicable extradition laws and treaties. It's very clear, it's the last sentence of Article 17. And in an interview, the former Supreme Court Justice Adolf Azcuna opined that surrender must be made pursuant to an applicable treaty. And since the Philippines is no longer a party to the Rome Statute, what then is the applicable treaty? Wala nang treaty. Dahil ang ini-invoke nga yung Rome Statute, wala na ngayon. Siguro si Justice Azcuna mas mahusay magpaliwanag.
Thank you very much, Madam Chair. Regarding the applicable provisions, the justification given by government for the surrender of former President Rodrigo Duterte to the ICC consists of two grounds. One is the warrant of arrest issued by the ICC and served through the protocol of the Interpol. The other is Section 17 of Republic Act 9851, which is the Philippine IHL law, and which provides that if a person is already being investigated for the crimes covered by this act, which includes crimes against, which includes the crimes for which President Duterte is being charged, is already being investigated by an international tribunal. The relevant Philippine authorities may surrender such person to the international tribunal, but it adds pursuant to the applicable extradition laws and treaties. Ngayon, ang tanong, ito bang last sentence na ito, which provides for the requirement that the surrender should be pursuant to applicable treaties, is still applicable since we don't have anymore the Rome Statute. Sa palagay ko po ay it's either we have the Rome Statute or not. If we don't have a treaty, then we cannot surrender the suspect to the ICC under this section, because this section requires that the surrender be pursuant to a treaty. Pursuant means in accordance with. And so if there is no treaty, in my view, we cannot make a surrender. On the other hand, if there is still a treaty that is due to the residual obligations that the Philippines may have even after withdrawal, pursuant to Article 127, Paragraph 2 of the Rome Statute, after withdrawal, the withdrawing state still obliged to cooperate with the ICC in relation to matters already under consideration by the court prior to withdrawal. So it again you go back to the question, is the Philippine situation something already under consideration by the court, by the ICC, prior to our withdrawal? In my view, Madam Chair, the answer is yes, because as of February 8, 2018, prior to our withdrawal, Fatou Bensouda, the former ICC prosecutor, already said that the Philippine situation is under preliminary examination as of that date. The question is whether or not the prosecutor is the court, because 127 paragraph 2 says under consideration by the court. And in my view, it is, because there are 4 principal organs of the ICC. The first is the presidencies. There's 1 president and 2 vice presidents. The second are the judicial divisions. The third is the office of the prosecutor. And the fourth is the registrar. So the office of the prosecutor is part of the court. Therefore, when Article 127, paragraph 2 says the matter must be under consideration by the court at the time before withdrawal, it includes consideration by the prosecutor. And so therefore, I believe we have residual obligations even after withdrawal. Question therefore is whether or not the warrant of arrest issued by the ICC after our withdrawal is something we have to cooperate with. Under 127 paragraph 2, in my view, yes. And therefore, in my view, the warrant of arrest is legal. However, I believe that the surrender is not, because the surrender must be pursuant to a treaty, and therefore our own law, Section 17 of Republic Act 9851, brought back the Statute of Rome, even after withdrawal, because it requires that a surrender must be pursuant to the applicable treaty. And therefore, in this case, the applicable treaty remains the Statute of Rome. And thus, we have to follow Article 59 of the Statute of Rome, which requires that the custodial state, namely the Philippines, must first bring the arrested person to a local court to determine 2 things: whether or not the person is really the one named in the warrant. Second, whether or not the person has been informed of the charges against him or her. This was not done. Therefore, there was, in my view, a violation in the act of surrender. However, Madam Chair, this is in the forum of the Philippines, but in the forum of the ICC, different rules apply. The rule in international law, Madam Chair, is that procedural laws are governed by the forum. So procedural safeguards are applicable only to the forum. If the Philippine Bill of Rights, for instance, which says that no person however, criminal proceedings before the ICC is governed by their own procedure. This is in accordance with private international law, that procedure is governed by Lex Fori, the law of the forum. And therefore, we go to the procedure in the ICC. In the ICC, I believe they follow what is called mali coptus beni detentus, meaning that even if the arrest is illegal, the detention can be legal. It does not automatically mean that if the arrest was illegal, the person arrested must be released. They will balance, it's a balancing act. They will balance the illegality of the arrest with the need to prosecute someone for very serious offenses under international law. And in their view, the balance weighs in favor of prosecution. They will prosecute, notwithstanding the violation of the procedure in the arrest and in the surrender, I mean. Therefore, it depends on whether you're talking about Philippine Forum or the ICC. The ICC, I believe, will follow their own procedure, whereas in the Philippines, as it is now pending in the Philippine Supreme Court, In my view, there is a violation and there will be consequences for that violation. Thank you, Madam Chair.
Thank you very much, Justice Azcuna. As usual, we received a very exhaustive opinion, and I'm certain that we will be guided by the same. I think Senator Cayetano would like to respond.
May I take advantage of the knowledge, wisdom, experience of Justice Azcuna, not only as a former Supreme Court justice, a recognized legal luminary, but as a member of the Constitutional Commission. Sir, can I take a step back? When the Constitutional Commission discussed the Bill of Rights, and in Section 2, the rights of the people to be secure in their persons, houses, papers, effects, against unreasonable searches and seizures of whatever nature and for any purpose shall be inviolable, and no search warrant or warrant arrest shall issue except upon 1, probable cause, 2, be determined personally by the judge after examination under oath of affirmation of the complainant and the witnesses he may produce, and particularly describing the place to be searched and the person or things to be seized. Am I correct, sir, that this was also a reaction to a period in the martial law where there were different kinds of warrant of arrest? Diba yung, I don't know the name of all of them, but ASO, so there were arrest warrants from many sources, including the military. So the commission, in its actions as representing the Filipino people, so fit. At least ito po yung tinuro sa amin sa Ateneo Law, that ang pinaghugutan nito, to be sure that if someone is arrested and it's not on a whim, it's not politicizing whatever, we will make sure by 1, judge lang ang pwede sa Pilipinas ang mag-issue ng warrant. Of course, the Supreme Court has already said may exception, like the Bureau of Immigration, just for the foreigners. But in general po, it has to be a judge. He can only issue it upon personally determining that there is probable cause after examination under oath of the complainant. Am I generally correct, Mr. Justice?
That is correct, Mr. Senator.
Yeah. So that is why in our 14 treaties for extradition with other countries, pare-pareho yung procedure that after the DFA receives the request for extradition, pupunta muna to sa isa nating judge. Para yung judge pa rin ang titingin. Am I correct? Am I wrong, SOJ? Tama, no? So that the judge can double check, and then he will be the one to either confirm or verify or issue the warrant of arrest. Then yun ang isa-serve ng local police. That's my understanding.
That is correct, Mr. Senator. The need for a judge to be the one issuing the order in cases of warrant of arrest and even search warrant is enshrined in our Constitution, because there were previous occasions prior to our adoption of our Constitution where instead of a judge, it just says an authorized officer. So it has to be a judge. In the case, however, of the ICC, the warrant of arrest was also issued by a judge. In fact, 3 judges issued the warrant of arrest under the ICC. Question is whether or not that warrant of arrest can be executed in the Philippines by Philippine authorities. And that is, I think, pending the Supreme Court now. There are pros and cons on that, but one issue there is whether or not the 3 judges pre-trial chamber of the ICC acted on probable cause or merely on sufficiency of evidence.
Yes.
But as I said, the provision on probable cause and the judges issuing the warrant are procedural safeguards that are good only for the forum and not applicable abroad. That is the limitation. Our constitution does not extend beyond our territory. Thank you.
Point I was going to, sir, is really the legal remedy of a Filipino citizen to run to our judiciary, which I asked Attorney Alexis Medina and go to him later. But my point, I think you already read my mind, Mr. Justice, and because you were saying we are not sure whether the judges or justices of the ICC went into probable cause or sufficiency, because we are also not sure if they issued the warrant based on a personal determination of the witnesses or complainants under oath. We do not know whether these are media reports or whether their prosecutors came here and interviewed them, no? So ang point ko, Mr. Justice, if I was being arrested and I'm not sure, I should be able to go to Philippine courts. Sa extradition treaty, sir, judge din naman judge ng US, judge ng UK ang nag-i-issue nito, no? And I checked with the ICC versus the other countries that signed with them. For example, the United Kingdom, no? It is the appropriate judicial officer who will issue the warrant of arrest of the UK. So from ICC, ido-double check pa rin ng ano. Ganon din po sa Canada. The Attorney General will apply ex parte for a provisional arrest before a judge. So it's not the fiscals, it's not the Prosecutor General. The Prosecutor General's job there is to bring it before a judge. Ganon din po sa South Korea, ganon din po sa Argentina, ganon din sa Paraguay at South Africa. That is why if we look at the information of surrender and transfer sa page 8 po. Number 8, sorry, not page 8, number 8. Nakalagay po dito, the date, time, and location of the appearance of the arrested person before the competent national judicial authority. Ang sagot po dito na ang pumirma, if I'm not mistaken, si Ambassador Lacanilao, do not know. So he did not know when he surrendered the former president whether they were brought before a judicial entity. So yun po yung main issue ko, Justice, na ang pagkaintindi ko, kung meron pong dispute sa interpretation ng batas or even sa issue of application of the law to certain facts, a Filipino citizen at any time can run to a Philippine court. But in this case kasi, he was denied the opportunity to run before a Philippine court because he was put on a plane and sent there, no? So even assuming I agree with everything you said now and I see the legal basis naman nung sinasabi nyo, sa akin, that remains to be the question on my mind. Can we deny a Philippine citizen the opportunity to go before a Philippine court? According to General Torre, and he can rebut this later on, is that 8 or 12 hours is enough, di ba? But I think mas malaking issue yon kung ang court nag-issue ng TRO within 8 or 12 hours unless the circumstance. I think at the time na the lawyers applied, hindi nga nila alam na isasakay sa eroplano di ba? But I leave it there. Feel free to comment, Justice. Ang point ko lang po, I think the spirit and letter of the Constitution is clear. It has to be before a Philippine judge to determine this, no?
In fact, Mr. Senator, the procedure in the ICC calls for bringing the person to a Philippine court first before surrendering the person to the ICC. So if you do not follow that, it can be argued that there is what they call abuse of process. And an abuse of process can be raised in the ICC itself. I think this is what will be considered in the September hearing scheduled by the pretrial chamber. Under the rules, objections to the legality or objections on abuse of process may be raised and resolved by the pretrial chamber, probably at the scheduled September hearing. So this remains still open, even in the ICC. The question of the validity of the surrender in view of the non-observance of Article 59 of the Statute of Rome itself. And the other thing is whether or not such abuse of process is curable. And again, that is debatable. It seems to me that the initial hearing on March 14th done by the pretrial chamber was an attempt to cure the deficiency of the absence of Article 59 procedure, because the three judges of the pretrial chamber in that hearing simply did what a local court would have done. That is, determine that the person is the same person named in the warrant of arrest, and that the person was informed of the charges against him or her. And after that, they said session adjourned. So they merely supplied the defect that the absence of the custodial state's local court created. So it remains whether or not male captus bene detentus will be applied by the ICC.
Yes.
Thank you.
Mr. Justice, yung